Welcome all, Vinoth here. Sedition law, and I'm going to discuss where it can be applied. It is applying for the anti-nationals and how it can be done. What are the drawbacks in the current law? How it can be improved? Whether it can be repealed or altered? Let's see into the topic. Come on. So guys, before going into the topic, I would like to let you know one thing. That is, the sedition law has been misguided. That is, the sedition law, before that earlier cases, the people has been misguided and they had been mentioned them as the anti-nationals. So I would like to define the sedition in a proper way, in a proper definition as given in the IPC section 124A, and I would like to let you know all what is mean by that. I had taken notes regarding it and I would like to let you know. It says that whoever by words either spoken or written or by signs or by visible representation or otherwise brings or attempts to bring into hatred or contempt or excites or attempts to excite disaffection towards the government established by law in India shall be punished with imprisonment for life, to which fine may be added, or with imprisonment may extended to 3 years, to which fine may be added, or with fine. So this is the proper definition of the sedition law of 124A. So I would like to give an explanation. Explanation number one: the expression disaffection includes disloyalty and feelings of enmity towards the government. Okay, it will comes under this 124A section of IPC. Explanation number two: comments expressing disapprobation of the measures of the government with the view to obtain their alteration by lawful means without exciting or attempting to excite hatred, contempt or disaffection do not constitute an offense under this section. So if the government is passing any law, or if they are if they are altering any law, if for that if anyone is speaking against it, it won't comes under the sedition. Okay. And explanation number three: comments expressing disapprobation or administrative or other action of the government without exciting or attempting to excite hatred, contempt or disaffection do not constitute an offense under this section. So if anyone is speaking about the administrative or other purpose of the government, it won't comes under the sedition law. So I would like to here ensure that there are many cases that this law is being misguided, and even the people who are protesting for their own interest and for their public interest, and it's like expressing their views also arrest under this 124A section. And it has been like a dictatorship. The definition even it's like a dictatorship. I had explained, you would have seen this definition in the screen. So it's like a dictatorship, and from my point of view I would like to say it should not be revoked or it should not be removed, but it should be altered. How? Two or three words should be included in the definition. What can be included? Yeah, if those the way of speech or way of showing the expressions or the way of expressing the slogans or anything, if it brings the violence or if it excites the violence towards the public and towards the government, then it should be punished. Until other than, it should not punish, because we are living in a vibrant democracy, and Our country is a vibrant democratic one. It's ruled by the people. It's only for the people. It's a people's rule. So it should be stay as like that. If the people's rule go against the people and the public, the same way of happening, then it should be punished. That is the way, if the slogans or way they are rising, the way they are speaking, if it rise any excitement or violence towards the people, then it should be punished. Then it should be comes under the sedition law. Actually, the sedition law is an British law, and it has been a part of 1860 Indian Penal Code. Okay, and I would like to let you know something. Actually, this is a draconian law. Okay, the law is like a forceful thing, and it's just a dictatorship. So I just want this to be altered but not removed. Why to be altered but not removed means, because there are lot of antisocial elements in our country. There are a lot of antisocial peoples. They can use this thing, if it get repealed, and they can use it in any other way to enter into the violence, and it will hurt people. So I'm saying that it should not revoke, but it should alter. If any speech or things are getting into the violence, it should be punished. That particular person should be punished. Until other than, even one is expressing their views for the public interest or for the any of the social interest, it should not be punished. And if they are opting for their things that they want to, and if they are asking with the government, and if they are saying with the government, it should not be punished. It is not the proper way. So I'm just, if this video is go or seen by the government or any of the officials, I hope it can be taken into consideration, in my point of view. And so there are a lot of things that have happened. So I would like to include some of the things into this Sedition 124A section. That is, this Sedition 124A section is actually a non-bailable offence, as well as number two, it is a cognizable offence. Cognizable offence means police can arrest the person without the warrant. That is, the cognizable offences are classified as one of the most dangerous offences, like murder, rape. These other things will come under it. But this sedition law also comes under this cognizable offence. It is not seems like a good thing. Why? Because it's not the thing that should be done. It is equal to the murder or rape. It is showing like us like that, and it should be comes under the non-cognizable offence. If it comes under it the court warrant must be needed to arrest. The difference between cognizable and non-cognizable is, if one person to be arrested, he must have the warrant from the court. That is called non-cognizable offence. So for cognizable offence, there is no need of warrant. The police officials can arrest the person directly. It is the difference. So I wish this law should be come into the non-cognizable offence as well as the bailable offence, so that people can express their views in a free way by ensuring without any incitement of violence. So if the violence has been happened, it should be taken into the court consideration, and court should decide about it. If there is any political person and he is coming and saying that one of the person has been said against me something, and it was against the government, so I should file him on a sedition case. If there is any of the kind of cases that were rising, it should taken into the consideration by the court. Court should involve in a way of judicial activism. Court should involve it directly, so that it can inquire it. If that is the case is true, and it can give the punishment to the person who is speaking against the particular MLA or MPs. If not, if the MP or MLA are doing any false affidavits, or if any false things they are filing, if they are any filing against the particular speech person, then the punishment can be given to the MLA or MPs. Then there will be a fear of anything. So I wish there should be a checks and balances in every aspects of this case and every aspects of this draconian law, and it was a British type of law. I wish this law to be altered but not revoked. And I would like to let you guys know that there was a landmark judgments regarding it. There are many landmark judgments. So those judgments are like what the Supreme Court said. Their landmark judgments in 1962, Kedarnath Singh versus State of Bihar. Supreme Court held that a citizen has right to say or write whatever he likes about the government or its measures by way of criticism or command, so long as he does not incite people to violence. So it was the Supreme Court order on 1962. And in 1982, P. Alavi versus State of Kerala, it has been said that where the court held that sloganeering, criticizing of parliament or this judicial setup did not amount to sedition. It is the way of the order that has been given in 1982. And in 1995, Balwant Singh and A. Ennor versus State of Punjab, Supreme Court says raising some slogan of Khalistan Jindabad a couple of times, which neither evoked any response nor any reaction from the public, cannot attract such punishment. So, just saying a slogan is not a sedition. Just showing their feelings through a slogan is not a sedition. And it is also not ever revoking the public. I mean, it is also not making the public to react. So the thing here is, if any of the words or speech or anything, if it goes against the government, and it should not be punished for it goes against the government. It should be punished if it raises the people's violence, if it makes to react the people. If the reaction of people is heavy due to that, then the person should be punished. Then there is a proper way of things can be said that we are living in a vibrant democracy, and it's our democracy and it's our people, we are doing it for so. If the people gets affected, those things can be done. Until other than the law that has been right now is not the things for a vibrant democracy. It is like dictatorship. It is like a draconian law. It should be repealed, it should be altered so that the way of people living can be ensured the happiness and joy forever. So the way, and it can be done so. I hope this will be done in a near future by the government. And for updated knowledgeable videos, my dear viewers, subscribe to our Breathe Knowledge channel and share it with all your friends, and hope this video is very useful for you. And I will coming up with the new and more knowledgeable videos in the upcoming sections. So subscribe to our Breathe Knowledge channel. This is Vinoth Kumar. Love you all and Jai Hind.